For Legal Eagles exclusively, Fundamentals of Contract Drafting, Navigating Contracts. ZAŁOCZNIKI. How to say ZAŁOCZNIKI do umowy in legal English. Legal practitioners in English-speaking jurisdictions often use the doublet schedules and exhibits to refer to attachments to a contract. In practice, you may encounter just one of these words standing alone in a contract. Or the order of words in the doublet may be reversed. In either of these situations, however, the meaning remains unchanged. Is there a difference in meaning between the words schedules and exhibits? Yes and no. Let me offer an illustrative example of a comparable pair of terms in the Polish language, namely majątek and mienie. Under Polish law, there is a definitive difference between these two terms of art, yet in all probability, the majority of Polish legal professionals will be unaware of this distinction. Nevertheless, lack of familiarity with the difference in meaning does not in any way thwart the careers of legal professionals who may use these two terms interchangeably in their generic sense. The same goes for schedules and exhibits, although they may be used interchangeably. Ken Adams, an expert on contract drafting endorsed by the American Bar Association, notes that in English-speaking jurisdictions there is a notable distinction in meaning. According to Adams, an exhibit is a standalone document, whereas a schedule contains information which was extracted from the body of the contract and placed at its end. Manual, page 181. Hence, an exhibit could be a document confirming registration of a company or its articles of association, or perhaps a contract template to be used when needed by the parties in the future, such as a template to grant the power of attorney. In contrast, a schedule could perhaps contain a list of the requirements a sub-processor of personal data would have to meet in compliance with the GDPR, a list that if placed in the body of the main agreement could potentially make it difficult to read. In some transactions, it may be customary to move parts of the main agreement to the schedules for a number of valid reasons. See Disclosure Schedules, Manual, page 183. However, Adams notes that there are other words used to indicate a załącznik in a contract, such as an appendix, an enclosure, an attachment, an annexure, and an annex. See section Polish Lawyer Beware below, which are generic terms and could be used in place of the traditionally used legal terms schedule or exhibit. Exhibits or schedules should be named consecutively as follows. Schedules. Schedule A, Supplier Contract Party. Schedule B, specific clauses to this MSA. Schedule C, Pricing Schedules. A different word should be used to mark second-level schedules. For example, Appendix 1 to Schedule A. Appendix 2 to Schedule A. It is not necessary to add of this agreement or hereof after internal cross-references. However, if an agreement contains schedules and there are references in a schedule to clauses in the main body and vice versa, you would want to clarify which sections you are referring to. For example, Section 3 of this schedule, Section 3 of the agreement. Be consistent when referring to schedules and exhibits. Don't refer to them in one part of the agreement as Exhibit 1, in another part as Exhibit 2 attached hereto, and elsewhere as Exhibit 5 hereof. Please note that Adams advises against capitalizing attachments, e.g. Schedule 4, Attachment number 6, etc. For more guidelines on using attachments in contracts, please go to A Manual of Style for Contract Drafting, 5th edition by Ken Adams, pages 181 to 186. For Legal Eagles exclusively. Thank you.